which we created for the awareness. Here's the volume.
Did you know that sexual harassment is a criminal offense? Is punishable with imprisonment of up to 3 years. Every organization.
Something called the Vishaka Guidelines, which was actually delivered by the Supreme Court because there was no domestic law in place for tackling harassment of women at workplace. The only challenge in that law was that there were no penal consequences for not complying with that law, because of which very few companies actually complied with those laws. In most of the cases, women actually had to go to court to even have an internal complaint committee set up. However, in this law in 2013, there are severe consequences for the organization for not complying with the law. Also, because of the unfortunate incident of the Nirbhaya case, the government has also amended the Indian Penal Code. So currently, not only is sexual harassment a civil offence under this code, it's also a criminal offence under the Indian Penal Code, where the imprisonment could be up to 3 years. So as I said, sexual harassment at workplace is punishable by law. So this law has come into being on the 3rd of December. It basically offers a right to women to demand a safe working environment. It is not only from employees but also from people when you come in contact. So for example, in a hotel industry, it's not only safety of women from employees of the hotel but also from other clients or guests within the hotel. So in case if the harassment is by any of the employees, then you will have the internal complaint mechanism, which I will kind of define or explain in some time. And in the unforeseen circumstances where a woman has been harassed by some other guest of the hotel, then in that case, if the woman wants basically you to help that lady, then you have to have a support system within the organization. Maybe send somebody along with the woman so that she can make a complaint to the police, because obviously she knows what happened with her, so she'll make the complaint to the police, but you are required by law to help her make a police complaint. So it is no longer a moral obligation in case a harassment happens within your premise. Now it's become a legal obligation, whether that person is your employee or not. The person who is making an allegation of harassment need not be your employee. So even a customer can actually make a complaint against your employee. The person against whom the allegation is made, he is basically called the respondent under the law. He has to be your employee. He could also be a contractor employee. A lot of housekeeping or other security could be outsourced. Even if those people harass somebody, as far as the guest is concerned, he is your employee. Whether you know that he is also even a contractor employee. So as a principal employer, if you are responsible, and here the definition of employee is very wide. So with your knowledge or without your knowledge, as long as he is working for you, in case there is an allegation of harassment by that person against a woman making an allegation, then your internal complaint committee is bound by law to provide redressal. So that's something which you have to keep in mind, that the employee definition is very wide. Also, it's not about limited to only office premises. So you may have your sales people who are going out on calls. As long as the person who's your employee, he is on work, so it's arising or during the course of employment, then his behavior, for his any bad behavior, if a woman wants to make a complaint, then it is workplace for the purposes of the act. So supposing if your hotel has actually sent you out here for this seminar, you are actually out here on work because your hotel has actually sent you out here, and somebody were to make an allegation that you misbehaved with her at this location, then you have the right to make a complaint to the internal complaint committee of that employee, of that person, because he's here on work. So very frankly out here what happens is, as long as the person against whom the allegation is being made is on work, you have the right to make a complaint to his internal complaint committee. So that's kind of a thing. So this has actually kind of created a new dimension in women empowerment or women's safety, where they are saying is that if he's an employee, you have a remedy with the internal complaint committee. So it's basically confidential, it's non-criminal in nature. However, if for some reason, if both the people are not employees of the organization, or even if the complainant is an employee, so supposing it's like your employee is harassed by a client, you still have an obligation to help her make a complaint against the client. Now if he's on work, So then obviously you can make a complaint to his internal complaint committee. Or if the lady insists that you have to make she wants to make a complaint to the police, then I'm saying you would anyway be doing it, but you have to assist her by sending somebody along with her to the police station to make a complaint. So this is providing an ecosystem of comfort to the woman to be able to make a complaint. So again, similar would be the case with malls, railway station, airports, because it's a workplace for somebody there. Again, as Shirin pointed out, the biggest challenge for this law is actually non-awareness. So the awareness of this law is pretty low. Last year we had actually done a survey where we found that 97% of the organizations, now this was done only in Nariman Point in Parel, which is the bastion of corporate India as far as Bombay is concerned, and we found that 97% of the organizations were either not aware that such a law exists, or they were not aware as to what all has to be done to comply with this law. 1 month later, Menka Gandhi in the Rajya Sabha actually admitted on the floor of the House that 90% of government organizations and private sector do not have a committee etc. in place. So when the government says 90%, it has to be more than that. It definitely can't be less than that. So I think so the biggest challenge for implementation of this law is the lack of awareness about the existence of the remedy etc. as provided under the law. Again, this also fits very well with your Atithi Devo Bhava. Also, a lot of people of you would not be aware that there is something called the Code of Conduct for Safe and Honorable Tourism, which was actually created with a document which was adopted by PATA along with UN DOC. I think this is one of the UN organizations, and this has been actually also adopted by the government of India. So when you are actually applying for recognition or renewal of any of your hotel approvals from the government of India, you are actually committing that you will pledge to commit towards the safe Code of Conduct for Safe and Honorable Tourism. So under this, basically, again, whether this conduct was there or not, you were anyway bound to have safety of women to be taken care. But I'm saying specifically under this Code of Conduct, you are not only bound by law, additionally, to ensure safety of women, but also out there it talks about creating training seminars etc. to ensure that women will feel safe within your organization. So this is something which possibly you may or may not be aware, because whether you were involved in the recognition process or not, but this is something which may not be to the knowledge of quite a few, that most of the hotels and restaurants who are actually approved by the government of India, or all of them, have to comply with this Code of Conduct as well. So I think so if you were to ask anybody on the road or anybody in the corporate sector, what are the things which they fear the most in this law? There are only two things which is against this law. One is this law is not gender neutral, so every man thinks why can't men be sexually harassed, and the second thing is women will misuse this law. If these two concerns are taken care, I believe there is no concern against this law. There are only two concerns like this. As far as the first concern is concerned about men being sexually harassed, it may happen. I don't know how much it happens. I think we are empowering women now. Once they get women empowered, hopefully they will harass women and men, and at that point of time, government will take that into cognizance and make it a gender neutral law. At this point of time, men are not sexually harassed. They may be harassed in a different ways. I haven't come across any men who were sexually harassed. So I think so that takes care of the first concern. The second concern being that women will misuse the law. I think so it's unfounded. If you look at this law, and when I take you through a salient features of this law, you'll find that making a complaint doesn't mean it's a false complaint. Today what happens is most of us think that if a woman has made a complaint, psychologically it's a complaint has been made and your image has been tarnished. I think so one has to understand in the organization that complaints can come in. Today also, if I want to go and make a complaint against anybody, I can go to the High Court and make a complaint against anybody for any reason. I don't require a law. So making a complaint is not about being right and wrong. Proving a complaint is about right and wrong, and that is what the internal complaint committee does. So in case the internal complaint committee does not do its job properly, then I can possibly agree with you that it's a false complaint, because if a false complaint is allowed and held to be true, then it's a misuse of the law. Otherwise, today you can make the law, you can cyclostyle and make complaints, and at the end of the day, the initial burden is on the woman to prove that she was harassed, however difficult it may be. So I think so these are the two basic concerns. I actually wanted to kind of put the cart before the horse, because everybody eventually will going to ask these two questions only. And if we have any questions despite that, then I think so it will be something wonderful to listen to. So to give you the entire emphasis of the law is actually on prevention. So right from creating a policy. So when you create a policy, you are telling your employees that we're taking this up very seriously. And whatever I'm saying is actually mandatory under the law also. But I'm saying that whatever is the mandate under the law is actually tilted towards prevention rather than redressal. So if you look at that way, even the name, prevention comes before prohibition and redressal for that matter. I think so the key of everything, you may have a policy in place, you may have a committee in place, but the key is behavioral change. As again Shireen pointed out, you may think sexual harassment is very cut and dry, black and white. This law is about the grey area, not about the black and white. For the black and white, you have the Indian Penal Code, anything, or already all those things in place. So here, basically, you have to sensitize your employees as to what can constitute sexual harassment. What may be harassment to one may not be harassment to the other. Again, in hotel industry, you have a lot of young people working. There will be a lot of senior people also working. So again, there could be a generation gap. The younger people may behave in a certain manner which may not be palatable to the senior people. So that becomes, so they may have objection to the behavior, because of which they may make comments about that. A colleague of a similar age may be okay with that. Some people may say, sweetheart, baby, sexy. It may be okay for a few women, it may not be okay for a few women. So what one has to understand is that sensitization is the key to prevention. That when you sensitize them, you tell them that it is not your intention which matters, it is the impact on the woman. Just because one woman finds sexy as a compliment doesn't mean every woman is going to find sexy as a compliment. So as long as you kind of comprehend and understand that, I think so you can make a great difference. Also talking about that outside the office also, your behavior if you are on work you can be accountable for. So there are several aspects like these which once you explain to the employees, and this is not only about male employees, because the woman can actually make a complaint against any gender. The only problem today, men cannot make a complaint. Otherwise, women can make a complaint of sexual harassment against a woman, against a man, as well against third gender, because now third gender also has been recognized as a gender for that matter. So basically these things have to be sensitized, and once you do that, our belief is that 80 or 90% of complaints will not actually come in, because most of the times the person, when he's saying something, may not have a bad intention, but he's used to saying a thing in a certain manner or kind of behaving in a certain way, and he basically thinks that a few people are okay with it, so the others should also be okay in a similar fashion, which is, it's not something which they have a bad intention. So when you sensitize them, they understand that this is something which may not be acceptable behavior. Despite that, if they do that, they have to bear the consequences of that. Similarly, women have to understand that if they make a false complaint, this is the first law of the country where women, when they make a false complaint, if the committee comes to the conclusion that the committee has made a false complaint, if the woman has made a false complaint, the same committee can take action against the woman. There is no law in this land which actually cuts both sides. In case a woman makes a false complaint, then you have to go and make another complaint. Yet the same committee can actually take action against the woman. So therefore there are a lot of inbuilt features again which I will explain to you. I'm going fast because of shortage of time. I just wanted to give you one more example. So last year you would have heard about this Madhya Pradesh High Court judge who harassed a session court judge. So basically there was this lady who was getting harassed by a sitting Madhya Pradesh High Court judge. So basically she resigned and she complained to the Madhya Pradesh High Court Chief Justice. The Chief Justice created a committee. She felt that she will not get any justice from the committee of brethren, because in the judges there is this brotherhood which is there. So she went and petitioned to the Supreme Court that the matter against the High Court judge should be heard by some Supreme Court judge. Now this matter is being heard in the Supreme Court. Madhya Pradesh High Court is being represented by Harish Salve, and the lady is being represented by Indira Jaising. So whenever Harish Salve was addressing the court, Indira Jaising would come up and interrupt in the middle. So the judge told Mr. Salve, you continue, do not get interrupted by Ms. Jaising. So Harish Salve in a joking tone said, "My Lordship, it is my pleasure whenever my learned counsel interrupts me. Now Indira Jaising, she caught up and said, "My Lordship, I take objection to this comment. This is a sexually colored remark. Would my colleague have said the same thing if a male would have interrupted him? We would have never come to know." The judge actually wrote this in his judgment. He said that today I have come to know another facet of law. It depends upon the facts of each case. People may argue that that she is being oversensitive, but once she says that no, then if thereafter you persist, then this will amount to sexually colored remark, which is sexual harassment. So just to kind of give you a perspective that this is something which can be as innocuous as this. Okay, so the idea is basically that, and again, obviously the court always also clarified that Hari Salve had no bad intention. So therefore that was another caveat which the court put in. But the idea is that sexual harassment is a lot more than touch and feel. So typically when we will think, we'll say unless you don't touch, there cannot be any element of sexual harassment. Sexual harassment is a lot more than that. So as I said, I've given you kind of why sensitization of employees is important. Similarly, why committees skill building, because they have to understand, they have to be able to understand what is right from wrong. They have to understand that the burden initially, however small, is on the woman. All these principles of natural justice is something which they have to understand. You will have 4 people, 3 of them are employees, 1 is an external member. The presiding officer has to be a woman who is employed at a senior level. 50% of them have to be women. So they are actually colleagues of yours. The idea there being that you will be much more comfortable making a complaint to a colleague rather than to an external person. Similarly, we are talking about a minimum 4-member committee. So here we are talking about collective decision. Typically in misconduct, you have an inquiry officer, 1 person takes a decision. You can always think about bias, etc. Here you have 4 people coming together and applying their mind and deciding what has to be done. So the chances of bias because of the collective decision goes down. Our advice to most of the organizations is that at least have 1 male in your committee. Since you can, despite law, in law you can have an all-women committee, but don't do that because you will alienate the men. At the end of the day, justice not only has to be done, it should seem to be done. So I think that's something which has to be kept in mind. So formulation of an anti-sexual harassment policy, displaying posters within your organization which highlight the legal consequences of sexual harassment, having an internal complaint committee at each location. A lot of people have done it at regional levels, they have done it at national level. It has to be at each location. So if you are a multi-locational hotel chain or have restaurants across several places, the law mandates that it has to be at each location. Again, all of this is so that the woman is comfortable making a complaint. If you are in Bombay and if you have a committee based in Delhi, how comfortable will the woman be to make a complaint is doubtful. So we're talking about letter and spirit. It has to be in both letter and spirit, and therefore an internal committee, the government has said that it has to be at each location. Again, the contact details of the committee should be known to everybody, because they need not come to your HR to make a complaint. They should actually ideally go to the complaint committee directly to make a complaint, so that tomorrow nobody makes an allegation that the HR tried to suppress the complaint. It's an independent body, you can go and make a complaint to them and that should be fine. And to ensure that you do all this, the government has also mandated disclosure requirements. So the committee has the end of the year has to file an annual report with the company and the district officer. In Maharashtra, the deputy collector in each district is the district officer, and then the company also has to include that in his annual report in case you are a private limited or a partnership or a public limited company. If you are a partnership, then you have to file a report with the district officer. So basically all these compliances, and in the report which the ICC, the internal complaint committee, makes to the organization, you have to mention not only complaints received during the year, disposed during the year, how many complaints were pending within 90 days, what is the action you had taken if any, but also what kind of awareness programs against sexual harassment did you carry out. So again, the entire emphasis of the law has been towards prevention, and if you do prevention, our belief is that it will not actually lead to complaints, it will actually prevent complaints. And I don't think so specifically with the hospitality industry where the percentage of women is high. The industry can actually afford to kind of push all these instances of harassment of women under the rug. In other industries they may still want to do that, but very frankly I think so there are few industries, and more so with hospitality where women are greater in number, that I don't think so you can afford to do that. So what are the major misconceptions of the law? We need not comply in case we do not have women employees. This is about women. She can be a customer as well. The complainant need not be your employee. We are not responsible for redressal in case if the incident occurs outside the office premises. So you may have a car pickup done. If the driver misbehaves, it is still workplace for the purposes of the act. You may provide transportation by buses to your employees to the nearest bus station. Even that is office premises for the purposes of the act. You may have salespeople going out. That is still office premises for the purposes of the act. Sensitize employees about the provision of the act will lead to increase in complaints. anything will be greater than 0. So if you basically think that way, that even one complaint is bad, the idea has to be that if there is sexual harassment, it has to be prevented. It is not about number of complaints. It's basically that you want to make sure that these smaller nuances are taken care, because if they're not taken care, then the person's intent gets strengthened, and then possibly he may do something which is more horrendous than before. So I think so that is this again. This misconception is unwarranted. Yes, you may get a complaint, but eventually it's false complaint or not is dependent on the committee. So getting a complaint, we have to in a sense destigmatize this process of complaint making. It is about deciding by the committee whether it was right and wrong. There is no need for sensitization because everybody knows what is sexual harassment. I gave you an example. I can give you several examples where you will be shocked that this can also constitute sexual harassment. So sexual harassment is a lot more. It is basically anything which is unwelcome to the woman, which has a gender connotation and basically unwelcome to her. So it is not your intention which matters, it is the impact on the woman. Any reasonable woman, how she would feel, the committee would perceive from that basis. Law can be misused by women, every law can be misused. I think so there are enough deterrent in this law at least to take care of it. Law is unfair as it is not gender neutral. I think so society will make it fair in the future. Vishaka guidelines is still valid law. Vishaka guidelines is no longer valid because that was done because there was no domestic law in place. The Supreme Court actually said that basically this law is the law of the land only till such point of time that when the legislation makes an appropriate law. So from 9 December 2013, Vishaka is not the law. Having said that, a lot of provisions in this law are based on Vishaka. But this law is much more detailed in procedure and processes as compared to Vishaka. So I think so another important thing is you have to get Vishaka out of it. The principles still remain, but this is a much more detailed process.